Okay, so why are we here on Mr. Jenkins? What happened?
Yes, there was, he was on bond and there's a new offense, so we're here for an arraignment. And then,
So he's on bond for 2 cases. He's now picked up a 3rd case. Is this right?
that's correct, yes.
Mr. Jenkins, you now stand charged with the offense of reckless driving. You are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 12, 2025 at 6:26 p.m., the officer observed the defendant's vehicle traveling at a high rate of speed on a feeder road without headlights on. The officer checked the speedometer and it read 80 miles per hour while the defendant's vehicle was traveling faster. This occurred in a 50-mile-per-hour zone. The officer observed the defendant's vehicle make an unsafe lane change, cutting off a motor vehicle and reaching a speed of 106 miles per hour with moderate to heavy traffic. The officer observed another unsafe lane change while attempting to catch up to the defendant's vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. Does he have a valid Texas
Yes,
driver?
Judge, eligible.
I'm now revoking your bond on the other 2 cases. You will go into custody with me because you picked up a 3rd case, sir. Goes with you.
Judge, he also is wanting me off the case. So I didn't know if we wanted to address that.
I'm not going to talk to you about this case. You have a lawyer. You need to talk to the lawyer.
Talk about my two kids before that, sir.
I'm not going to talk to you about this. We'll put you in back if you want. I can give you a new lawyer today. I'll give you a lawyer, another. If you want to get on, and I'll provide you another lawyer. It's the 3rd case. Unacceptable. Mr. Jackson, you now stand charged with another case. You were charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 18, 2025, the officer observed the defendant's vehicle traveling 78 miles per hour in a 60-mile-per-hour zone, have an expired registration, and failed to maintain financial responsibility on Interstate 45. The officer noticed a prominent odor of marijuana trailing the defendant's vehicle, and a traffic stop was initiated. The officer observed the defendant to be in the driver's seat with a black bag and a female to be in the front passenger seat. The defendant rolled down the passenger window, and the officer observed a cloud of smoke emitting from the vehicle with an odor of marijuana. The defendant was asked to step out of the vehicle with the black bag. The black bag was opened, and the officer observed a clear jar with a green leafy substance known to be marijuana based on training experience, along with a digital scale and individual baggies. The defendant was searched for weapons, and the officer found more packages of marijuana inside his private area. The weight of the marijuana was 1.82 ounces.
And Your Honor, if I could adjust probable cause.
Okay.
Your Honor, so while I don't dispute the reason for the stop here, I think there's a couple things that stand out. So there is a alleged smell of marijuana that comes from the vehicle, and then an alleged cloud of smoke that comes from the vehicle as the windows are open. So first off, the officer doesn't specify whether this is a cloud of course, burnt marijuana, which I would assume, or vaped marijuana, because those are 2 very different things with 2 very different distinct smells. Additionally, if the officer is pulling them out and looking for marijuana and he has this cloud, then he would be looking for burnt marijuana, right? So he would be looking for a roach. He would be looking for a blunt. What he does is he looks inside of a plastic bag. If we have embered marijuana or we have a lit blunt, it's certainly not going to be in a plastic bag without the smell of burning plastic. Additionally, the marijuana that is found in the bag is in a sealed glass jar container, something that would not emanate a smell because a glass jar is essentially smell proof. In this instance, I think we have an officer who went too far with the search, because we have Mr. Jackson here who did not admit to possessing marijuana, did not admit to this being marijuana. The statute, of course, requires that this has to be marijuana, and we know we have the issues, of course, with the hemp bill. But Your Honor, if you're not aware, you can go into any head shop, purchase flowered hemp, open it, and it smells, looks, everything about it is identical.
I understand,
to
and
marijuana.
that, yes, I agree with you for a beyond a reasonable doubt standard, but here, this is just mere probable cause, right? There's a good stop, goes to the car, smells marijuana. There's a plume of smoke that comes out. Not only that, Sean, he signed an affidavit that he wasn't going to drive. He's not supposed to be driving
And,
regardless.
and I get the driving aspect of it, but I don't see how a cloud of marijuana from burnt marijuana gets you inside of a plastic bag. At that point, it becomes a fishing expedition as opposed to looking for the actual contraband, which he suspects that would be in the vehicle.
I don't know. I mean, I think that there's certainly enough to go forward. Beyond a reasonable doubt, I don't know. But this is just a probable cause standard, which is the low stand, So
I understand.
I'm gonna find that there's probable cause to go forward with your case, Mr. Jackson. I ordered you not to drive. He's a driver in this car.
Yes, Judge.
Okay. I'm now revoking your bond. Goes with you. Sorry, Sean, but he promised us he's not going to drive. He signed an affidavit. He knows. He knew.
And Your Honor, will a new bond be set? And if so, can we get that amount set?
So I'll leave the first bond as is. The first case, I'm going to do it at 5,001.
Okay. So first case, 5,001, and then the new case, of
I'll
course, would be
leave
bonded
the
out
first
as.
one or the second one as is, though.
Which case number?
So the one that's on page
14 or 13?
14, that one gets revoked to 5,001.
Okay. Okay. Thank you, Your Honor.
Okay, thanks,
I believe
Sean.
That's all.
You don't have anything else with us today?
Nope. I'm in Fort Bend for the rest of the day.
All right. Good luck, my friend.
Thank you, Your Honor. May I be
Weekend.
excused? You too.
All right. Bye.
Bye.
Good morning, Mr. Humphrey. So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes,
You have
Judge.
the right to have an attorney present. If you're not afforded, one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight as they were in a dating relationship for 2 years. The complainant stated they ended the relationship in 2023, but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100 plus times from a no caller ID. The defendant spoke to the officer and admitted to calling the complainant 100 plus times from his primary phone number and his secondary number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. I mean, really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works, no weapons. Life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just life's way too short. Really. You have the ability to hire a lawyer, Mr. Humphrey. Or do you need a court-appointed lawyer? Okay. I want my community safe, man. That's all I want. Please, please. I have an application on file already. So I'm going to have you sign a release of Victoria. I'm going to have you meet with police for your bond conditions. I'll provide you a lawyer here momentarily. Just think before you act. Come on. If you don't mind, give me your cell phone number so I can give it to the lawyer, and then I'm going to have him reach out to you momentarily. You guys need to get on the same page today. You need to stay in contact with him, and he'll tell you when you have to come back to court. Don't pick up any new cases. You already know what's going on.
So
Okay, please.
Dennis,
No. We just write it because I don't want to.
Does it
Don't say
end in
that loud.
591? Your number?
No, you said there's an end in 591.
Yes.
It end in 91.
So yeah, what are the last four digits?
Oh, yeah.
3591.
Yes, I have it.
Okay, don't worry about it. So this is Abel. He's going to reach out to you here momentarily so you guys can talk about the case. Or it's going to be on the reset we give you. We're going to give you his number now.
I did just call his number and it went straight to voicemail. I'm assuming he has his phone off.
Sorry.
Okay, so regardless, I don't have you attached to the case yet. Let me see. Do you have him attached to the case yet, Vic?
No, but I'll write his number on the reset.
Okay, we're going to give you his number. It is your responsibility to stay in touch with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but stay in touch with him and he'll tell you when you have to come back. If he tells me he can't get a hold of you, I'm going to revoke your bond. You pick up a new case, I'm going to revoke your bond. Just be good. Don't have any contact with this person. I don't care what's going on in your life. Don't contact this person. Do you understand?
Sure.
If she tries to contact you, don't answer the phone. If she texts you, don't reply. If she comes to your house, don't answer the door. You're the one that's going to be sitting in there. All right?
Sure.
All right, come on.
Donald
Good morning,
Johnson.
sir. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. So this is the one that we were talking about the other day, right? Where it looks like initially a magistrate found no PC, right? But then we have a refile the next day. Will you go ahead and read PC? You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer met with a complainant who stated that the defendant is her ex-husband, and the complainant advised that on August 25th, 2024, the defendant was at her residence regarding a visitation. As the two children went into the home, the complainant told the defendant to leave. The defendant then pushed his way into the home and pushed the complainant against a wall, causing pain. The officer observed surveillance footage showing the defendant push and strike the complainant in the upper chest area.
Oh, there's a strike.
Yes, Judge.
Okay. Mr. Reichert, I'm going to find that there's probable cause to go forward with your case. A protective order has been issued in this case. Get to know it. If you violate the protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up. You're not to have contact with this person and not to go where she lives or where she works. Do you understand? No. I can give you a lawyer.
Sir?
I can give you a lawyer if you'd like.
Yes, sir.
Talk to the lawyer, and the lawyer can come up and talk to me. I just don't want you to say anything. Believe it or not, I'm trying to help you because I've got a bunch of DAs here. Whatever you say, they're going to try to use it against you. All right. Do you need a lawyer?
Yes, sir.
All right. I'm going to have you sign a reset of Victoria. We'll have you get in the jury box. If you can file the conditions, no contact, no weapons,
Yes,
please.
Judge.
Have you signed the conditions, and then we'll provide your lawyer here momentarily. Okay? Please, sir.
You need this, Judge.
No, I have it on file. Thanks.
Judge, I got appointed to Mr. Richard today. It's Richert.
Yeah.
And he has no contact as part of his conditions in a
Correct.
MOAB. He does have two daughters with the complainant.
Court comes to order. You need to talk them out.
He wants to know if he can still go there for visitation for.
No, she doesn't want him to come over. That's what I heard. Right?
Say would be a.
Well, Judge, would you at least allow him to get a third party to pick up the daughters?
I mean,
Okay.
come up.
Maybe we could do that as sort of a middle ground.
Is it Richard or is it Reichert?
Richard.
Mr. Richard, I like to follow the wishes of the complaining witness. So if she doesn't want to have contact with you, then that's what we do. If she wants to have contact with you, then I'm fine with it. But I have to hear it from them to see what they want.
Okay.
What the state has told me so far is that they don't want, this person doesn't want to have contact with you. The last thing I want is for you to go over there, you accidentally bump into her, words exchange, you're the one that's on bond. You're the one that's going to end up going back to jail. So it's more of like a preventative measure, right? So there's no issue if you have someone else to try to facilitate contact with your daughter. The complaining witness is only the ex-wife. It's none of the daughters, right?
Correct, Your Honor.
Right. So however you want to have contact with the daughters, great. Just don't go over there. You can always use someone else to try to like be an intermediary to get them to you however you want.
So someone else could go pick up my children and bring them to me.
Sure, of course. Yeah. But that's probably the safest way so you don't bump into this person. She says something to you where it just inflames the passion and, you know, that's the last thing we want.
Is someone going to explain to her that someone else will be picking up my children? If I'm not allowed to
I guess,
contact her?
can you reach out to her and let her know that that's what we're going to try, that's what they're going to try to do so that she's aware of, you know, even leaving however you want to. Yeah, we'll have the state reach out to her to let her know that this is how the agreement that they're going to try to work, so to have someone. How old are the daughters?
8 and 14.
Yeah. Yeah, do you mind, please? Yeah, okay, so they'll reach out and do that and then, you know, hope maybe a grandparent or someone else or,
They're worse.
okay, well,
Thank you, Judge. I appreciate it.
for sure. Ms. Donaldson, is this an arraignment?
No, Judge, this one was you rolled it to today because we were supposed to be trying to get proof of I'm sorry, I'm at the hospital with my grandfather. We were trying to get proof of him being in Spring Hills.
I'm sorry about your grandfather.
Thank you.
Did you get anything?
We got a letter from them, but I think it might be the same one that was sent to you all, and it just said that he was there with no discharge date, and that was pretty much it.
Let's see. Let me see what, did you get it or did Victoria get it?
I'm sorry, you said did
The letter you said that you guys got, did you get it or did Victoria get it?
she sent one to me? She said that she sent one to Victoria. I'm not sure if it's the same one. If not, I can forward it over.
Give me a second, let me see.
Okay.
Hunt. Remember, this is the one that they said it's in a facility, but we don't have proof. We don't know.
That's the one that, I think I sent it to her what I had. It was something from the mom and it says it was in.
Get something new?
Oh, no.
No, we haven't gotten anything new. I don't know. I need some kind of proof, not just their word, you know?
Okay, I can send over this document that she sent me, and then
Sure.
Would you mind sending it to Victoria and then she can print it out for me, please?
yeah, sure, I can do that right now.
Thanks.
Yes, Judge.
She's gonna email you something.
Oh. Counsel for reset.
Go here, ma'am. Ma'am, go here. Everybody, make sure you exit out this side. please.
Thank you. That's okay. You're doing good.
Counsel for reset.
Good morning, Mr. Huggins. So understand that your lawyer is here because he wants me to set you a bond. I don't know. I don't know anything about you. I've never met you before. I know that you're going to tell me it's little bunnies jumping in the woods, but really, what matters to me are two things. Number one, what are you charged with? Are you a dangerous person? And more importantly, most importantly, are you going to go back to the demanding jurisdiction? I have no idea. We have to get to know you in the short time now, 20 seconds, just to see who you are. So, Mr. Kim, tell me about it.
Yes, Judge. Defendant is wanted at East Baton Rouge Parish, Louisiana for a domestic abuse, battery, strangulation, or equivalent of impeding breath. State would be opposed to bond. Defendant is currently on deferred adjudication for aggravated robbery, where he was the driver and there was a firearm involved. During the aggravated robbery deferred, he picked up a misdemeanor possession of marijuana, which alone, that wouldn't be sufficient to bring up the court. But the fact that one of his conditions on his deferred adjudication was to not consume any marijuana, he violated said provisions, and then now he picks up a strangulation. The warrant was 10 days old when he.
So this is this case here, this is a new case.
Yes, Judge. It was issued out January 14th. And so because of the repeated violations, the offense being one of them, the state would be opposed to bond.
If I may, Your Honor,
Please.
Mr. Huggins has already retained counsel for the New Orleans case. Eric Hayes, I have been in communication with him. I think it's important for the court to know, as it relates to the allegations out of Baton Rouge, that it was actually the complaining witness mother who hired us to be here this morning on behalf of Mr. Huggins. I also think it's important for the court to know, even though it is triable facts for the Louisiana case, she also sent us over several videos. We're confident that he will appear in New Orleans because he's already retained counsel. We believe that he won't have a problem complying with all of the things that's been outlined here in Harris County, seeing that he does have strong ties to the community and he is employed. And because of that, Your Honor, we do believe that there are conditions that can be put in place if the court elects to give him a bond, such as an ankle monitor, to ensure that, one, the court knows where he is and that the community is safe. And then also he has already retained counsel, Mr. Eric Hayes, for that matter, out in Baton Rouge. So I believe I have no reason to believe he won't answer to Baton Rouge, and I don't have any reason to believe he won't comport with the conditions here in Harris.
You're a dangerous person, man. How old is he? 22, 23?
Yes, Judge. And to add, for what it's worth, he already had a GPS ankle monitor as a condition of his deferred when the strangulation happened, or at least according to the conditions. And
Was he not supposed to go there too?
No, it's just one of the arguments made by counsel was to have a GPS monitor secured.
This is that, it's such a short time. He's picked up this case. He's picked up, I guess, a weed case, and he's on probation for an aggravated robbery. I mean, really.
Full disclosure, there was a motion to adjudicate, but in the Brenham case that was dismissed. I don't have the files for the Brenham one, but I presume because the deferred was cured that they didn't pursue it. But he was only charged and it was later dismissed, but it was 2023. So obviously very recent.
Let me ask you this. Is he on bond did they file a motion to adjudicate on the
Aggravated robbery, but then that was dismissed on October 16th.
So he has no holds now, right?
Currently,
No,
yes, Judge.
And it was dismissed because the Brenham marijuana case was ultimately dismissed.
Yes.
I'm not comfortable giving you a bond now, Mr. Huggins. I think you're a dangerous person, man. You picked up that case over there. You're on probation for an aggravated robbery where there's a gun, and I don't know if there's shooting involved, but the good news is that it's only Louisiana. We have buses coming in and out probably 2 times a week to take people back because we have so many people from Louisiana here. So once you waive extradition, Monday, Tuesday, you'll be back in Louisiana. So he's not going to be sitting for not too long. I don't feel comfortable doing it, man. You scare me, dude. So you said he has waived, right?
Yes, Judge.
Sorry, counsel. But the good news is that he'll be back lickety split, in was it Lafayette?
It's East Baton Rouge,
East
and
Baton Rouge.
currently the aggravated robbery doesn't have a new MAJ based on the impeding or the strangulation, and so I can't speak for the trial bureau, but if they decide to revoke.
Mr. Huggins, you got to understand, when you're on felony probation, something like that, you got to live with a halo on your head because you could be looking at 20 years, man. All right.
Thank you,
Thanks.
Your Honor.
Thank you, Judge.
Yes.